NENT. This agreement is made and entered into by and between the City of Naperville, hereinafter referred to as the City, and the Naperville Professional Firefighters Union, IAFF Local 4302, hereinafter referred to as the Union. Preamble. It is the intent and purpose of this agreement to set forth the parties' agreement with respect to the rates of pay, hours of employment, fringe benefits, and other conditions of employment that will be in effect for employees covered by this agreement, to prevent interruptions of work and interference with the operations of the city, to encourage harmonious labor management relations, to provide effective and efficient services to the public, and to provide procedures for the prompt, equitable, and peaceful adjustment of grievances as provided herein. The city and the employees covered by this agreement regard themselves as public servants who agree to conduct themselves with honor and integrity, both on and off duty, in order that they may merit the respect and confidence of the general public. Now, therefore, the parties agree as follows. Article I. Recognition and Representation. Section 1.1 Recognition. The city recognizes the union as the sole and exclusive bargaining representative for all full-time sworn personnel employed by the City of Naperville Fire Department with the rank of fire captain and below. Persons encompassed within the above-referenced bargaining unit shall individually and collectively be referred to herein as employee and employees. Persons excluded from the bargaining unit are all other city employees, including but not limited to the fire chief, deputy chief, battalion/division fire chiefs, any employee excluded from the definition of firefighter as defined in Section 1603(g) of the Illinois Public Labor Relations Act, civilian employees, part-time employees, and all other supervisory, managerial, professional, short-term and confidential employees as defined by the Act. Section 1.2 Fair Representation. The union recognizes its responsibility as bargaining agent and agrees fairly to represent all employees in the bargaining unit, whether or not they are members of the union. The union further agrees to indemnify, defend, and hold harmless the city and its officials, representatives and agents from any and all claims, demands, suits or other forms of liability, monetary or otherwise, and for all legal costs resulting from any failure on the part of the union to fulfill its duty of fair representation. Section 1.3 Gender. Unless the context in which they are used clearly requires otherwise, words used in this agreement denoting gender shall be construed to refer to both male and female employees. Section 1.4 New Hire Orientation. The city will provide a union officer with an opportunity to share information regarding the union and the collective bargaining agreement, as well as enrolling new hires in the IAFF FIBA, with a new hire or City of Naperville and IAFF 43021 2025 to 2027 CBA. Group of new hires during their initial orientation. The union officer will not be compensated by the city for time spent during such orientation. Article 2 Dues Checkoff and Fair Share. Section 2.1 Voluntary Dues Checkoff. During the term of this agreement, the city will deduct from each employee's regular paycheck the uniform, regular union dues for each employee in the bargaining unit who has filed with the city a lawfully written voluntary dues authorization form. An employee may revoke his/her dues checkoff authorization at any time by giving written notice to the deputy fire chief, human resources, and the union president. The city will send the dues collected under this section to the union treasurer, along with a list of names from whom deductions have been made, each pay period. The actual dues amount deducted, as determined by the union, shall be uniform for each employee in order to ease the city's burden in administering this provision. The union may change the fixed uniform dollar amount once each year during the life of this agreement by giving the city at least 30 days advance written notice of any change in the amount of the uniform dues to be deducted. If an employee has no earnings or insufficient earnings to cover the amount of the dues deduction, the union shall be responsible for collection of dues. The union agrees to refund to the employee any amounts paid to the union in error on account of this dues deduction provision. Employees who do not choose to become dues-paying members of the union shall have the option of paying a fair share fee to the union for collective bargaining and contract administration services rendered by the union. Becoming a union member or paying union dues or alternatively a fair share fee is not a condition of employment and is strictly voluntary pursuant to the U.S. Supreme Court decision in Janus v. AFSM. Section 2.2 Fire Pack. The employer agrees to deduct monthly fire pack deductions in an amount certified to be current by the secretary-treasurer of the local union from the pay of those employees who individually request in writing that such deductions be made. The total amount of deductions shall be remitted biweekly by the employer to the treasurer of the union. An employee may, at any time, on forms provided by the union, revoke fire pack deduction and shall submit such revocation to the city with a copy of such revocation form to the union. Section 2.3 Indemnification. The union shall indemnify and hold harmless the city, its elected representatives, officers, administrators, agents, and employees from and against any and all claims, demands, actions, complaints, suits or other forms of liability, monetary or otherwise, that arise out of or by reason of any action taken by the city for the purpose of complying with the provisions of this article, or in reliance on any written checkoff authorization furnished under any of the provisions of this article. Article 3 Union Bulletin Board. Section 3.1 Bulletin Board. The city agrees to furnish suitable space for bulletin board, with a locking glass cover, of approximately 3 feet by 4 feet in a mutually agreeable, non-public area in each fire station, which the union may use to post notices pursuant to the provisions of this article. One set of keys to the bulletin board will be given to fire chief or duty chief, and the other keys shall be retained by the union president or the president's designee. No other union notices or materials shall be posted on any other city property or equipment unless otherwise mutually agreed between the city and the union. Section 3.2 Use. All postings on the union bulletin board shall be non-political, non-abusive, non-inflammatory, non-defamatory, and non-discriminatory, in accordance with city policy. The union will limit the posting of union notices and/or bulletins to such bulletin boards. Section 3.3 Removal of posted material. If the city believes that material posted on any or all union bulletin boards is in violation of this article, the fire chief or his designee shall notify the union president, who shall promptly see to the removal of the material from the bulletin board. If the union president is not available, the fire chief or duty chief may remove the material and notify an available union steward of such action. Any disputes about material which has been removed may be the subject of a grievance. Section 3.4. Union responsibility. All costs incidental to preparing and posting union material will be borne by the union. The union is responsible for posting approved material on its designated bulletin board and for maintaining such bulletin board in an orderly condition. Article 4. Management rights. Except as specifically modified by any and all other articles of this agreement, the union recognizes that the city retains and does not waive all traditional rights to manage and direct the affairs of the city in all its various aspects not modified by the terms of this agreement. The city recognizes that it shall act consistent with the authority granted to it under the Constitution, federal law, and state law, except to the extent that rights under state law are not limited or are modified by the terms of this agreement, including the management rights provision. These rights and powers include but are not limited to the following: to plan, direct, control and determine all the operations and services of the city, to supervise and direct the working forces, to establish the qualifications for employment and to employ personnel subject to the Illinois Municipal Code, 65 ILCS 10.2-1-1 and the Firefighter Substitute Bill SB 834, to schedule and assign work and employees, to establish work and productivity standards and, from time to time, to change those standards, to assign overtime, to determine the methods, means, organization and number of personnel by which operations are conducted, to make, alter, and enforce reasonable rules, regulations, orders, policies and procedures, to evaluate and promote employees, to demote, discipline, suspend and discharge employees for just cause, probationary employees without cause, to change or eliminate existing methods, equipment, or facilities, and to carry out the mission of the city, provided, however, that the exercise of any of the above rights shall not conflict with any of the express written provisions of this agreement. Notwithstanding the foregoing, the parties agree that in conditions of civil emergency, which may include, but are not be limited to, riots, civil disorders, tornado conditions, floods, or other catastrophes, as may be reasonably declared by the mayor or his authorized designee, the city may temporarily suspend the provisions of this agreement, provided that wage rates shall not be suspended, and provided that all provisions of this agreement shall be promptly reinstated once a civil emergency condition ceases to exist. Article V. Hours of work and overtime. Section 5.1 Purpose. This article is intended to define the normal hours of work and to provide the basis for the calculation and payment of overtime. Nothing in this article or agreement shall be construed as a guarantee of hours. Section 5.2 Work Schedule. Bargaining unit personnel assigned to shift shall normally work a duty shift of 24 consecutive hours, beginning at 7 a.m., followed by 48 consecutive hours off. When an employee is scheduled for, or requests a 12-hour period of time off, the normal working hours would be from 7 a.m. to 7 p.m., or from 7 p.m. to 7 a.m. the following day. For purposes of Section 7K of the FLSA, the city has adopted a 27-day work cycle. Bargaining unit personnel assigned to 40-hour workweeks shall normally work an 8-hour day plus a 1-hour unpaid meal period during a 7-day work cycle. Beginning and ending times may vary, as determined by the city, but are usually 7 a.m. to 4 p.m. or 8 a.m. to 5 p.m. Lunch periods will normally be scheduled after the 3rd and before the 6th hour of the workday. If the employee is unable to take a lunch break due to operational issues, he shall be paid for the unused portion of his lunch break. From time to time, a change in these work hours may be necessary or appropriate. The employee's supervisor must approve this change. The city may offer flexible work schedules to personnel assigned to 40-hour workweeks. The employee's supervisor and the fire chief must approve flexible work schedules. Should it be necessary in the city's judgment to establish individual schedules departing from the normal workday, normal workweek or work cycle, to change an employee's shift assignment, or to temporarily change an employee's assignment from shift work to a 40-hour workweek, e.g., for training, alternate duty assignment, other assignments for bona fide operational reasons, to a maximum of 30 calendar days, unless otherwise agreed by the employee, the city will give, if practicable, at least 24 hours advance notice of such change to all employees whose normal workday, normal workweek, and/or normal work cycle is changed. The union and the city agree to allow bargaining unit employees assigned to 40-hour workweek positions to work an alternative flexible schedule as outlined below, if the employee so chooses. The flex time schedule will be a 9-day, 80-hour pay period with alternate Fridays off. The employee will work what is the equivalent of an 8.88-hour workday. Time off is accrued per Section 15.1 of the CBA, however, time off will be debited on an 8.88-hour time frame under this flex time election, changing the total numbers of days, but not altering the accrued hours as outlined in the CBA. For bargaining unit members electing to work this schedule, the union agrees to waive the terms set forth in Article 5 Section 5.4 regarding overtime for 40-hour workweek employees. Instead, the city and union agree that overtime will be calculated as any time actually worked outside of their scheduled workday. Section 5.3 Kelly Days. Shift employees shall be granted one 24-hour Kelly day every ninth scheduled shift, in order to reduce average work hours to an annual average of 49.9 hours per week. The city shall schedule these Kelly days, pursuant to Section 15.4, Step 1 Scheduling, each year in order to reduce average work hours in compliance with Fair Labor Standards Act provisions. For overtime purposes, scheduled Kelly days shall not be considered hours worked. Shift seniority, i.e., most to least, shall be utilized to make initial Kelly day assignments. Work reduction days shall be taken on the assigned date and may not be exchanged, except among employees on the same shift pursuant to Section 6.1 of this agreement. Section 5.4 Overtime Pay. Bargaining unit employees shall receive overtime pay or compensation time, see 5.11, at the rate of 1 1/2, 1.5, times their regular hourly rate of straight time pay for all hours actually worked outside their scheduled hours or in excess of 24 consecutive hours of actual work in a duty shift. Overtime shall be paid in 15-minute increments. Periods of less than 15 minutes per day worked in excess of the normal workday shall not be counted when calculating overtime pay, in accordance with regulatory rounding rules. Overtime work must be approved by the employee's chief officer, or his designee prior to the commencement of the work. Employees working a 40-hour workweek shall be eligible for overtime at a rate of 1 1/2, 1.5, times the regular hourly rate of straight time pay or compensation time, see 5.11, for all hours worked in excess 40 hours in 7-day work cycle. Overtime work must be approved by the employee's division chief or his designee prior to the commencement of the work. Section 5.5 Overtime Assignment Definitions. The Naperville Fire Department allocates overtime duty to serve a multitude of staffing needs. Overtime assignments typically fall into three different categories. Shift overtime, overtime duty distributed in order to satisfy the shift staffing levels determined necessary by the city to cover the routine delivery of emergency services by the Operations Division. Non-shift overtime, overtime duty distributed to ensure staffing required for the completion of short-term or temporary staffing and other special duty assignments not associated with the routine delivery of emergency services. Emergency call-out, overtime duty distributed in order to provide additional staffing to supplement response to community emergencies. This overtime may be restricted to individuals with specific or specialized training. Mandatory overtime assignment, the fire chief or his designee may mandatorily assign overtime work for shift or special duties to individual employees in accordance with the provisions of this agreement. There will be a separate mandatory overtime holdover list of all bargaining unit shift employees, which shall initially be created on the basis of reverse seniority. New employees will be added to the top of the list when they become eligible. If the city determines that it is necessary to hire back, the next employee on the list with the necessary qualifications and/or rank from the offgoing shift shall be used to fill the vacancy. If an employee works or is assigned to work the overtime, such employee shall not be mandatorily assigned overtime under this procedure until their name comes up again in rotation on the same list. This list will be kept in a location accessible to all members. When personnel are assigned mandatory shift overtime, it shall be indicated on the daily staffing sheet. Exceptions to personnel on the list for mandatory overtime. The following personnel shall normally be exempt from mandatory overtime, as set forth immediately above, in a specific instance. Personnel who have worked or are scheduled to work 48 hours are exempt from mandatory shift holdover and their name shall be passed. Personnel who are not on duty are exempt from mandatory overtime holdover, and their name shall be passed. Personnel scheduled off the next shift day regardless of vacation, Kelly day, or scheduled switch day, whether AM or PM, are exempt from mandatory shift holdover and their name shall be passed. Probationary personnel will not be eligible for mandatory overtime until 90 days after successful completion of their initial NFD orientation/training program and subsequent assignment to shift duty. If the individual next on the mandatory overtime holdover list is ineligible due to rank not needed, that individual shall be passed over. If the individual has a previous commitment to an approved class or department event, e.g. CPAT, CPR, PubEd, has waste, the individual would violate a court order. Special duty overtime callout. The city retains discretion to select employees for special duty overtime assignments which the city anticipates to last 4 hours or less, and or to cover city council meetings. Postings for remaining special duty overtime will be made in 3 steps, if the city determines time allows. Special duty overtime opportunities that occur with sufficient advance notice shall be posted by the overtime notification process, which can include text, email, phone call or other timekeeping platform. This overtime will be filled based on overtime lists or current union overtime policy if appropriate. Postings shall designate the specific level of skill, certification, special team membership, etc. required for the special duty overtime assignment. If the overtime duty has not been filled within 7 days prior to the date of the special duty assignment, an additional notification of the available overtime shall be transmitted by the overtime notification process. For short notice special duty overtime opportunities, i.e. less than 7 days notice, the overtime group page shall be used as the first step for this type of callout. Any special duty overtime not filled 24 hours after transmission of the overtime notification and less than 7 days prior to the event, shall be assigned from the mandatory overtime holdover list of the shift preceding the date of the special duty assignment. Individuals who accept a special duty overtime assignment may not accept shift overtime that overlaps with any portion of the special duty overtime period. If an individual finds coverage for a special duty assignment, then the individual may accept the shift overtime. The union shall be responsible for obtaining personnel for regular shift overtime, short notice shift overtime, and emergency shift overtime. When overtime is needed, the chief or his designee shall contact the designated union representative and state where the overtime is needed and the duration of the overtime. In the event of an overtime vacancy created within 24 hours of the next shift day, the rank responsible for creating the overtime shall have the first right of refusal. If no member of that rank accepts the overtime, the opportunity shall be offered to other eligible ranks in descending order to fill the vacancy. Should no member of any eligible rank voluntarily accept overtime, a forceback will be implemented to cover the vacancy. The union shall have reasonable discretion to change or modify the overtime call-out procedures for regular shift overtime, short notice shift overtime, and emergency shift overtime, subject to the provisions of this agreement. Any change to the overtime call-out procedures shall be subject to review by the city. Section 5.6 Remedy. In the event that an employee demonstrates she was not afforded an overtime opportunity to which the employee was clearly entitled under this agreement, the sole remedy shall be to give such employee the opportunity to work the next available overtime assignment of a similar nature. This remedy shall only apply one time to the next available overtime assignment that the employee would normally be available for. If the employee is offered and does not take that assignment for any reason, they would return to their original position on the list. This clause would not apply if the overtime is cancelled or amended. Section 5.7 Special Deployment. In the event an employee is temporarily assigned to a special deployment in connection with a state mobilization of MABA's resources, said employee may be temporarily assigned a different work schedule. Hours worked will include time spent traveling to and from the remote location, and hours actually worked at the site, but will not include unassigned time or sleep time. During such special deployment, while temporarily assigned to a different work schedule, hours worked in excess of 49.9 in a 7-day period shall be paid at the overtime rate or deployment policy rate, whichever is greater. Section 5.8 Emergency Holdover. All bargaining unit personnel are subject to emergency holdover. The fire chief or his designee may hold over an entire shift, or any part thereof, to deal with a situation that would constitute an ongoing emergency or work in progress. Every attempt will be made to release emergency holdover personnel as soon as possible. Section 5.9 Callback Pay. Employees who are called back and report to work outside their normal hours of work, i.e., hours not contiguous to their normal shift or on a day not regularly scheduled, shall be paid for all hours actually worked outside their normal shift, with a minimum of 2 hours pay at the employee's applicable rate. This provision shall not be applicable to scheduled overtime. Section 5.10 Compensatory Time. When an employee works a higher back or otherwise earns compensatory time off, he may elect to bank the hours as compensatory time in lieu of receiving monetary compensation in that pay period. In consideration of the city offering this limited compensatory time, the city and the union agree, in furtherance of Section 7.05 of the Fair Labor Standards Act, to place restrictions on the use of compensatory time under circumstances which they agree would constitute an undue disruption of the department's operations. This banked time may be used to take time off at a future date when the leave calendar might otherwise be full and prevent normal scheduling of time off, or in the case of a personal emergency where time off is needed. Effective January 1, 2012, any time accrued and categorized as compensatory time will be transferred into a higher back bank at 1.5 hours per hour worked. The following procedure shall be followed for utilizing the higher back bank/comp time option. Accrual limits: time shall be banked at a rate of 1.5 times the number of hours worked, e.g., 24 hours worked equals 36 hours banked. 7G. Overtime will not qualify as bankable time. A maximum of 480 hours may be held in the bank at any one time. If the full amount would cause the balance accrued to exceed the maximum 480 hours, only that which will bring the balance to 480 hours will be banked and the remainder will be paid as overtime. Requesting to use higher back bank time. In order to request higher back bank time, the employee must at that time have the equivalent of time and 1/2 of the time requested in the bank. The time must be requested in increments of 12 hours, 0700 to 1900 hours, or 1900 to 0700 hours, or 24 hours, 0700 to 0700. Higher back bank days may be used consecutively, however, they may not cause an individual to exceed 90 consecutive calendar days off when combined with vacation, Kelly, and trade time. For advanced scheduling of the higher back bank, employees shall notify the shift commander by following the approved notification rules for time off. All requests will be recorded with the date and time they are received. An employee must, at a minimum, notify the shift commander 1 hour prior to the start of their scheduled shift that they will be utilizing their higher back bank. Requests for higher back bank use on the following holidays shall be denied: New Year's Day, Easter, 4th of July, Thanksgiving, Christmas Eve, Christmas Day, New Year's Eve. Unduly disruptive days: if a higher back is necessary to cover the employee's requested time off, the shift commander shall so advise the employee as soon as practical. All higher back and force back rules shall apply in order to fill vacancies caused by a higher back bank request except as expressly modified by this article. It is agreed by the parties that the implementation of such higher back and force back rules will necessitate additional administrative and operational efforts in order to fill such higher back slots, thus causing undue disruption to the department's operation. If a higher back is necessary to cover the employee's requested time off, the parties hereto agree that such request cannot be filled within a reasonable period of time without unduly disrupting the operations of the fire department. In such case, the employee shall have the following options as illustrated below. To direct the shift commander to forego the request for time off and requisition payment for 36 hours of bank time, e.g., 24 hours requested at time and a half equals 36-hour reduction in higher back bank, on the next regular payroll check. To withdraw the request and to resubmit a request for leave at another time that does not cause a higher back. Take the leave requested, or if the leave requested causes a higher back, the scheduled employee taking the leave shall be designated as having taken an unduly disruptive day, and the scheduled employee's higher back bank shall be reduced by time and 1/2 for each hour granted off, e.g., 24-hour higher back at time and a half equals 36-hour reduction in higher back bank. If no higher back is required, the request shall be deemed to be not unduly disruptive, and the employee taking the leave shall have his higher back bank reduced hour for hour, e.g., 24 hours off equals 24 hours reduction in higher back bank. If, during the course of a shift, manning falls below the minimum and a higher back is needed, e.g., sickness or injury, the employee using his higher back bank will not be charged with an unduly disruption. In addition, employees will not be charged with an unduly disruption if the deputy chief, or his designee, raises the minimum manning for the day to staff additional vehicles. Sick calls do not trigger an unduly disruptive day. Additionally, a long-term injury or illness, defined as 120 days off or physician's note stating the employee is to be off for 120 days or greater. Overage costs, the city should incur no additional overtime costs due to higher back bank usage. As such, when an overrun/holdover occurs in higher back bank usages in increments of less than 24 hours, the employee using the higher back bank time shall have the following options. The overage time will be charged to the employee using the higher back bank and his/her balance will be reduced accordingly to credit the employee providing coverage for the higher back bank usage, e.g., 1.5-hour reduction for each hour of overage. In such cases, the employee's higher back bank will be allowed to accrue a negative balance. The request to use higher back bank time form shall include an agreement which shall authorize the city to withhold from the employee's compensation any amount needed to reimburse the city for any higher back bank time that he/she uses prior to being entitled to the time if the employee separates from service with the city. In the case of overage costs, the requesting and covering employees may mutually agree that the overage time be considered an emergency duty trade subject to approval of the shift commander and there will be no additional balance reduction. In the case of overage costs, the employee using the higher back may submit a written request to the fire chief or his designee for both employees to be paid due to extenuating circumstances. Cash out. If an employee elects to cash in any portion of their higher back bank, a request shall be made by the employee through an approved electronic means. The city automatically will cash out any compensatory time in excess of 36 hours on December 31st of the year the time was earned. The accrued hours will be paid at the employee's current regular rate. Indemnification. In consideration of the employer's agreement to allow employees to establish time due compensatory time banks and to schedule time due in accordance with the terms and conditions of this section, the union agrees to the following. Subject to the parties' agreements and adoption of the alternative procedure described in paragraph B, the union and its bargaining unit members agree to defend, indemnify, save and hold harmless the city, its officers, agents and employees, from any and all damages, costs, expenses and penalties arising from any complaint or allegation that these restrictions on the use of higher back bank/compensatory time do not comply with Section 7(5) of the Fair Labor Standards Act regarding the use of compensatory time. Any and all disputes that may arise between the parties as to the administration of this section shall be resolved through the grievance arbitration procedure, Article 9 of this agreement, except that such grievance shall be filed at Step 3. The parties' agreement to utilize the grievance procedure to resolve any disputes arising under this section is based upon the authority vested in them under Sections 8 and 15(b) of the Act, 5 ILCS Sections 315(8), 315/15(b). Such agreement is also made in reliance upon the Supreme Court's decision in 14 Penn Plaza LLC v. Pyatt, 129 S.CT 1456, 186 LRRM 2065, 2009, that such disputes shall include claims or allegations that any restrictions on the use of time due available to employees from their compensatory time banks as established under this section do not comply with Section 7(5) of the FLSA, 29 U.S.C.A. Section 207. In the event that any such grievance is advanced to arbitration, the parties further stipulate and agree that the arbitrator's remedial authority shall be limited to making the grievance whole by granting, consistent with applicable Section 7(0) standards of the FLSA, the cash value of any time due in dispute based on the then applicable overtime rate or awarding additional compensatory time off and shall have no authority to award any attorney's fees or any penalties against the parties. Section 5.11 Electronic Timekeeping. All bargaining unit employees must register their time worked by utilizing the current approved timekeeping process. Company officers will have the ability to adjust employee timesheets that are made in error to assure accuracy of an employee's record of work time. There is no expectation that any employee will be required to extend their workday for exchange shift meetings. If the city determines that any of the above terms needs to be amended, added to, or otherwise changed, it shall not do so until it has consulted with the union and engaged in any requested impact bargaining over the proposed change. Article 6 Guidelines governing trade of leave or work time. Section 6.1 Scheduling of trade of leave or work time. This article applies to employees assigned to 24-hour shifts. The deputy chief shall be responsible for the overall administration of the FLSA calendar, however the shift commanders and the captains who stand in for them shall be responsible for accurate documentation and consistent application of policy with regard to recording changes to scheduled time off or trade of work time on a daily basis. Changes to scheduled time off and trade of shift time may be allowed after the time off schedule has been established, provided this process does not become disruptive to fire department operations and provided city staffing requirements are met. The following guidelines shall normally apply. General guidelines. Personnel may request a change of leave or trade of work time in 12 or 24-hour increments. In order to complete a change of leave or trade of work time, employees must notify the shift commander utilizing the approved work scheduling method. The number of consecutive calendar days off shall not exceed 90 at any time by combining vacation, Kelly, compensatory time, and or trade of shift days. After having taken 90 consecutive calendar days off, personnel must work a minimum of 2 consecutive shift days before another day off can be scheduled/taken. A trade of work time shall not have the effect of increasing the number of compensable hours of work for employees. The hours worked by the substitute employee shall be excluded by the city in the calculation of hours for which the substitute employee would otherwise be entitled to compensation, including overtime compensation. If a substitute employee works another employee's scheduled work shift in accordance with this section, then the hours worked by the substitute employee shall only be counted as hours worked by the employee who was originally scheduled to work that shift. It is expressly understood that as a result of approving a voluntary request to exchange or trade shifts, the city will not incur any overtime liability. A maximum of 4 officers may be scheduled off on any shift day for each of the 10 fire stations. There shall be a minimum of 2 fire captains or 1 fire captain in the shift commander position and an acting captain. If a shift commander is scheduled to be off, personnel holding the rank of captain shall fill the position of shift commander. Requests to move scheduled leave time must be received on the approved form with all relevant signatures and approval by the shift commander or his designate a minimum of 3 calendar days in advance of the date of the earliest change requested. The deputy chief or his designate must approve requests for changes to scheduled time off less than 3 calendar days out. Swaps. An intra-shift swap of scheduled time off between members of the same shift shall be treated as a change of scheduled time off. Employees may change or swap time with assigned Kelly time for vacated seniority numbers of the same shift only with the approval of the deputy chief or his designee. These swaps can only be approved 30 days prior to the vacated Kelly. Personnel on the same shift who are in different Kelly groups may mutually agree to exchange Kelly groups once a year, prior to step 1 of the scheduling process pursuant to section 15.4. This exchange shall be permanent unless both parties agree to exchange Kelly groups at a later date. Trades. Requests for shift trades of scheduled work time between employees of different shifts must be approved by each of the shift commanders of the affected shifts or their designates. The trade request must be received by one of the shift commanders involved or their designates on the approved form with all relevant signatures normally 3 calendar days in advance of the date of the earliest trade requested. In the case of unforeseen circumstances or events, trades shall be approved by a shift commander up to the start of the earliest affected shift. In extenuating circumstances, a shift commander may approve a trade of work time up to the start of an employee's shift. Personnel from different shifts who agree to an intershift trade may elect to defer a payback date up to 12 months from the earliest trade date. Captains and lieutenants may trade with each other provided that all other trade, time off, and city staffing requirements are met. It is understood that a trade request is a voluntary agreement between 2 parties. In the event neither half of the trade has been fulfilled and one of the parties leaves the department, the agreement becomes null and void. It is understood that, upon separation from the fire department, retirement, resignation, termination, any outstanding trade time owed by the person leaving the city's employment will be accounted for, paid back, out of the employee's final paycheck. If an employee becomes ill/injured after working their portion of a trade, the payback date may be changed, or may be deferred up to 12 months from the earliest trade date. Probationary personnel are eligible for trades with other probationary personnel immediately upon completion of their NFD orientation/training program assignment to shift. However, trades with non-probationary personnel shall not occur until 90 days after successful completion of their initial NFD orientation/training program and subsequent assignment to shift. Personnel may voluntarily participate in a one-way trade with other personnel who are conducting union business. There shall be no expectation of repayment of the trade by the city. Section 6.2 48-hour rule. In order to ensure the safety of personnel and operations, Naperville Fire Department personnel may not work more than 48 consecutive hours of shift work. This includes, but is not limited to, scheduled shift time, trade time, and shift overtime. A minimum 12-hour break is required after working 48 consecutive duty hours. This 48-hour restriction is not intended to prohibit an employee's participation in non-shift activities including, but not limited to, attendance at, or instruction of, department-approved training sessions. Standby at community/special events. Attendance at meetings. Fire prevention/public education activities, i.e., inspections, safety town, public education presentations, etc. Notwithstanding the foregoing, under extenuating circumstances, e.g., emergency work in progress, community emergency or disaster, individuals may be required to work in excess of 48 hours by order of, or approval by, the fire chief or his/her designee. Section 6.3 Less than 12-hour trades of work time. Shift employees may request a trade of scheduled work time for less than 12 hours provided. A less than 12-hour trade of work time amongst employees shall be voluntary by the participating employees. A less than 12-hour trade of work time shall be permitted on a position-for-position basis, i.e., company officer for company officer, firefighter/paramedic for firefighter/paramedic or firefighter for firefighter, and shall not result in staffing deficits at the affected station or shift, as determined by the city. A trade of work time under this section shall not have the effect of increasing the number of compensable hours of work for employees. The hours worked by the substitute employee shall be excluded by the city in the calculation of hours for which the substitute employee would otherwise be entitled to compensation, including overtime compensation. If a substitute employee works another employee's scheduled work hours in accordance with this section, then the hours worked by the substitute employee shall only be counted as hours worked by the employee who was originally scheduled to work that shift. It is expressly understood that as a result of approving a voluntary request to exchange or trade shifts, or portions thereof, the city will not incur any overtime liability. A less than 12-hour trade of work time may be for a period of time up to a maximum of 11 consecutive hours. Employees' trading time under this section shall obtain the approval of the company officer. Less than 12-hour trades may be approved with limited notice, provided it meets the requirements within this section. Less than 12-hour trades of work time shall not be permitted as a routine or continual practice amongst individual employees over a period of time unless approved by the deputy chief. Trades under this section may not be used to avoid being late for work. Article 7. Labor Management. The city and the union mutually agree that in the interest of efficient management and harmonious employee relations, it is desirable that meetings be held when mutually agreed to in advance between union representatives and representatives of the city. Such meetings should be requested at least 7. A trade of work time under this section 7 days in advance by either party by placing in writing a request to the other for a labor management meeting and expressly providing the agenda for such a meeting. The other side may then add to the agenda and return the amended agenda to the other side. Such meetings and locations shall be mutually agreed to before being held, and the purpose of any such meeting shall be limited to discussions concerning the implementation and the general administration of this agreement, a sharing of general information of interest to the parties. Changes in non-mandatory subjects of bargaining. It is expressly understood and agreed that such meetings shall be exclusive of the grievance procedure. Grievances shall not be considered at a labor management meeting, nor shall negotiations for the purpose of altering any of the terms of this agreement be carried on at such meetings. Attendance at labor management shall be limited to 5 bargaining unit employees selected by the union president and 5 persons designated by the fire chief. No bargaining unit employee attending such meeting during his non-work time shall be compensated by the city, nor shall any bargaining unit employee attending such meeting during his or her working hours suffer any loss in compensation. Article 8. Seniority, layoff, and recall. Section 8.1 Definition of seniority. For purposes of this article, seniority shall be based on the employee's length of continuous full-time employment as a sworn firefighter in the employ of the city. Seniority shall not accrue during any period of time when the employee is in a non-paid status for 30 or more consecutive days, such as a suspension or unpaid leave of absence, except as otherwise provided by law. Conflicts in seniority between two employees having the same accrued seniority shall first be resolved on the basis of hire date and, if a conflict still exists, then on the basis of their order of rank on the eligibility list from which they were hired, with the employee higher on the list being considered the more senior. Section 8.2 Seniority and Rank. Seniority in rank is defined as the employee's length of continuous service in that rank based upon date and order of promotion. Section 8.3 Probationary Period. All new employees and those hired after their termination of seniority shall be considered probationary employees until they complete a probationary period of 12 months of continuous employment. Fire administration may elect to extend the probationary period for an employee in accordance with the allowances of Illinois statutes. During an employee's probationary period, the employee may be suspended, for up to 3 duty days or less, or terminated by the city, with or without cause. No grievance shall be presented or entertained in connection with such a suspension or termination of any probationary employee. Section 8.4 FFII/Advanced Firefighter. All bargaining unit employees are expected to attain Firefighter 3, Advanced Firefighter, or Office of the State Fire Marshal equivalent certification status through the Illinois Office of the State Fire Marshal within 5 years of their date of hire. Employees who have not achieved this status shall be ineligible for promotion to a higher rank, or able to advance beyond Step 6 of the pay scale as defined in Appendix A. When a new employee is hired by the Naperville Fire Department with 5 or more years of full-time fire service experience, excludes volunteer and part-time positions, and advanced technician firefighter, or OSFM equivalent, they will be moved to Step 6 upon the completion of probation. Any current employee off of probation who meets that criteria will also be moved to Step 6 upon the ratification of the contract. Section 8.5 Seniority List. Within 4 weeks of the effective date of this agreement, and thereafter on or before January 1st of each contract year or when changes are made, the city will post and provide the Union and Firefighters Pension Board with a seniority list setting forth each employee's seniority date, and each employee's seniority and rank. The city shall not be responsible for any errors in the seniority list unless such errors are brought to the attention of the city in writing within 14 calendar days after the city's posting of the list. Section 8.6 Layoff. During the term of this agreement and to sunset upon the date of December 31, 2027, the city agrees not to lay off any bargaining unit member. All language below will not be applicable during the duration of the agreement but will once again apply at the expiration of this agreement. The city, at its discretion, shall determine whether layoffs are necessary. If the city determines that layoffs are necessary, employees will be laid off as provided in 65 ILCS 5/10-2.1-18. No later than 30 calendar days prior to the effective date such a layoff, the city shall provide the union a statement of the reasons necessitating the layoffs. The parties agree that the layoff of active employees shall be necessary only as a last resort after other cost-saving alternatives have been fully considered. Upon request of the union, the city agrees to meet and confer to discuss the reasons for the layoff, and to consider any union-proposed alternatives or methods to mitigate or avoid the layoff. Alternatives to layoff that shall be considered are: seeking savings through reductions in budgeted expenditures, personnel reductions through attrition, including voluntary separation incentives, redeployment of existing department resources to achieve savings, identification of additional sources of revenue for the services provided by the fire department. The parties agree that the meet and confer process shall not delay the layoffs beyond the 30-day period, unless the parties agree to extend the period by mutual agreement. The parties further agree that the city shall have final authority whether to accept any proposed alternatives to layoffs and to implement layoffs, and that these decisions shall not be subject to either the grievance arbitration or interest arbitration process. Provided, however, the union reserves the right to file grievances limited to disputes relating to a claim that the city failed to follow the requirements of this article in administering any layoff process. The parties further agree that as to any negotiations as of the terms of a successor agreement, each side reserves its respective rights, and this agreement is without prejudice to such rights. Section 8.7 Recall. Employees who are laid off shall be placed on a recall list. If there is a recall, employees who are still on the recall list shall be recalled in the inverse order of their layoff. No new sworn personnel will be hired to perform bargaining unit work before the recall list described herein is exhausted. Employees who are on the recall list shall be given up to 21 calendar days to report back to work from date of the notice of recall, provided that the employee must notify the fire chief or his designee of his intention to return to work within 10 days after receiving notice of recall. The city shall be deemed to have fulfilled its obligations by mailing the recall notice by registered mail, return receipt requested, to the mailing address last provided by the employee, with a copy to the union, it being the obligation and responsibility of the employee to provide the fire chief or his designee with his latest mailing address. If an employee fails to timely respond to a recall notice, his name shall be removed from the recall list. Section 8.8 Termination of Seniority. Seniority in the employment relationship shall be terminated for all purposes if the employee quits, is discharged in accordance with this agreement, retires or is retired, has been laid off for a period of 3 years or more, or accepts gainful employment while on an approved unpaid leave of absence from the fire department, unless the employee received specific prior written consent from the city manager that seniority would not terminate. The city may terminate an employee's seniority for all purposes in the employment relationship if the employee is absent for two consecutive regularly scheduled workdays without notice or authorization, unless there are extraordinary circumstances beyond the employee's control that prevent notification. Fails to report to work at the conclusion of an authorized leave of absence or vacation unless there are extraordinary circumstances beyond the employee's control that prevent notification. Is laid off and fails to notify the fire chief or his designee of his intention to return to work within 10 days or to report for work within 21 days after having been recalled. The foregoing list shall not be construed as a limitation upon the city's right to discharge employees for cause, probationary employees without cause, in accordance with the terms of this agreement. Section 8.9 Effects of Layoff. During the term of this agreement, if the city exercises its discretion to lay off an employee, then the employee shall be afforded an opportunity to maintain the medical insurance in effect at the time of layoff by paying, in advance, the full applicable monthly premium for their insurance coverage. If an employee opts to maintain medical insurance under this section, then such employee shall be permitted to continue the insurance coverage for a period of up to 24 months from the date of layoff. Employee rights and benefits under this section are subject to the terms and conditions of the applicable insurance policy or plan. An employee who is laid off will be paid for earned, but unused, vacation time. Any other payments for accrued time, if any, shall be governed by the applicable article or section of this agreement. Article 9 Grievance Procedure. Section 9.1 Definition. A grievance is defined as a complaint arising under this agreement raised by an employee or the union against the city that there has been an alleged violation, misinterpretation, or misapplication of a specific provision of this agreement. Section 9.2 Procedure. The parties acknowledge that it is usually most desirable for an employee and his immediate supervisor to resolve problems through free and informal communications. If, however, the informal process does not resolve the matter or is not utilized, the grievance will be processed as follows. Step 1. An employee, with or without the union, or the union alone in the case of a union grievance, shall submit the grievance in writing to the deputy chief specifically indicating that the matter is a grievance under this agreement. The grievance shall contain a complete statement of the facts, the provision or provisions of this agreement which are alleged to have been violated, the relief requested and the signature of the grievant. All grievances must be presented no later than 7 calendar days from the date of the first occurrence of the matter giving rise to the grievance or no later than 7 calendar days after the grievant, through the use of reasonable diligence, could have become aware of the occurrence of the matter giving rise to the grievance. This timeline may be extended if mutually agreed upon by both parties. The deputy chief or his designee shall offer to meet with the grievant and a union representative, if desired by the grievant, to discuss the grievance within 7 calendar days after his receipt of the grievance from the grievant. The deputy chief shall render a written response to the grievant and the union within 7 calendar days after the Step 1 grievance meeting, if any. If no such meeting is held, then the deputy chief shall respond to the grievance within 7 calendar days after his receipt of the grievance. Step 2. Grievance is not settled at Step 1 and the grievant wishes to appeal the grievance to Step 2 of the grievance procedure. It shall be submitted in writing to the fire chief or his designee within 7 calendar days after receipt of the city's answer at Step 1 or his/her designee. The grievance shall state the basis upon which the grievant believes the grievance was improperly denied at the previous step in the grievance procedure. The fire chief or his designee shall offer to meet with the grievant and, if desired by the grievant, a union representative to discuss the grievance within 7 calendar days after his receipt of the grievance from the grievant. The fire chief or his designee shall then provide a written answer to the grievant and the union within 7 calendar days after the Step 2 grievance meeting, if any. If no such meeting is held, then the fire chief or his designee shall respond to the grievance within 7 calendar days after his receipt of the grievance. Step 3. If the grievance is not settled at Step 2 and the grievant wishes to appeal the grievance to Step 3 of the grievance procedure, it shall be submitted in writing to the city manager or his designee within 7 calendar days after receipt of the city's answer at Step 2. The grievance shall state the basis upon which the grievant believes the grievance was improperly denied at the previous step in the grievance procedure. The city manager, or his designee, shall offer to meet with the grievant and a union representative/employee's legal representation, if desired by the grievant, to discuss the grievance within 10 calendar days after his receipt of the grievance from the grievant. The city manager or his designee shall then provide a written answer to the grievant and the union within 10 calendar days after the Step 3 meeting, if any. If no such meeting is held, then the city manager or his designee shall respond to the grievance within 10 calendar days after his receipt of the grievance. Section 9.3 Arbitration. If the grievance remains unresolved, the union may, by written notice to the city manager, invoke arbitration as described below within 15 calendar days after receipt of the city manager's answer at Step 3, or within 15 calendar days of the date such answer was due. The parties shall attempt to agree upon an arbitrator within 10 days after receipt of the notice of referral. In the event the parties are unable to agree upon the arbitrator within said 10-day period, the parties shall jointly request the Federal Mediation and Conciliation Service to submit a panel of 7 arbitrators who are members of the National Academy of Arbitrators residing in Illinois, Wisconsin, or Indiana, or other mutually agreed upon source. Each party retains the right to reject one panel in its entirety and request that a new panel be submitted before the striking process begins. The parties shall determine by the toss of a coin who shall strike first, then alternately strike names until one arbitrator is selected. The person remaining shall be the arbitrator. The arbitrator shall be notified of his/her selection and shall be requested to set a time and place for the hearing, subject to the availability of union and city representatives. The city and the union shall have the right to request the arbitrator to require the presence of witnesses or documents. The city and the union retain the right to employ legal counsel. The arbitrator shall submit his/her decision in writing within 30 calendar days following the close of the hearing or the submission of briefs by the parties, whichever is later. The parties may agree to waive this requirement. More than one grievance may be submitted to the same arbitrator where both parties mutually agree in writing. The fees and expenses of the arbitrator and the cost of a written transcript, if any, shall be divided equally between the city and the union, provided, however, that each party shall be responsible for compensating its own representatives and witnesses. Section 9.4 Limitations on authority of arbitrator. The arbitrator shall have no right to amend, modify, nullify, ignore, add to, or subtract from the provisions of this agreement. The arbitrator shall consider and decide only the question of fact as to whether there has been a violation, misinterpretation, or misapplication of the specific provisions of this agreement. The arbitrator shall be empowered to determine the issue raised by the grievance as submitted in writing at the second step, unless otherwise mutually agreed by the parties. The arbitrator shall have no authority to make a decision on any issue not so submitted or raised. The arbitrator shall be without power to make any decision or award which is contrary to or inconsistent with, in any way, applicable federal laws, applicable state laws, not otherwise superseded by a lawful provision of this agreement pursuant to Section 15 of the Illinois Public Labor Relations Act, or of rules and regulations of administrative bodies that have the force and effect of applicable law. The arbitrator shall not in any way limit or interfere with the powers, duties, and responsibilities of the city under law and applicable court decisions. Any decision or award of the arbitrator rendered within the limitations of this section shall be final and binding. Section 9.5 Time limit for filing. No grievance shall be entertained or processed unless it is submitted at Step 1 within 7 calendar days after the first occurrence of the event giving rise to the grievance or within 7 calendar days after the employee or the union, through the use of reasonable diligence, could have obtained knowledge of the first occurrence of the event giving rise to the grievance. If a grievance is not presented by the employee within the time limit set forth above, it shall be considered waived and may not be pursued further. If a grievance is not appealed to the next step within the specific time limit or any agreed extension thereof, it shall be considered settled on the basis of the city's last answer. If the city does not answer a grievance or an appeal thereof within the specified time limits, the aggrieved employee may elect to treat the grievance as denied at the step and immediately appeal the grievance to the next step. The parties may by mutual agreement in writing extend any of the time limits set forth in this article. Section 9.6 Miscellaneous. No member of the bargaining unit who is serving in an acting capacity shall have any authority to respond to a grievance being processed in accordance with the grievance procedure set forth in this article. Moreover, no action, statement, agreement, settlement, or representation made by any member of the bargaining unit shall impose any obligation or duty to be considered to be authorized by or binding upon the city unless and until the city has agreed thereto in writing. Employees selected by the union to act as union representatives in the grievance procedure shall be known as stewards. The names of the employees selected as stewards and employees serving as union executive board members who may represent employees at steps 1 to 3 of the grievance procedure shall be certified in writing to the city by the union. Grievance meetings shall be scheduled in a manner that does not interfere with city operations. A union representative will be allowed to represent an employee grievant at a meeting held pursuant to steps 13, if so requested, during his working hours, if necessary, without loss in pay. Self-representation. Nothing herein shall prohibit an employee from exercising his/her right to self-representation under steps 1 through 3 of the grievance procedure, so long as any grievance settlement does not violate the terms of this collective bargaining agreement and a copy of the settlement agreement is provided to the union, and provided a union representative was afforded an opportunity to be present at any settlement conference. The city and the union may, by mutual agreement in a specific case, agree to utilize an expedited arbitration procedure. Section 9.7 Bypassing Steps. The parties may by mutual written agreement in a specific instance, agree to bypass one or more steps of the grievance procedure. Section 9.8 Exclusivity of grievance procedure. The grievance procedure set forth in this article shall be the sole and exclusive means for discussing and processing items subject to the grievance procedure. Article X, No Strike, No Lockout. Section 10.1 No Strike. During the term of this agreement, neither the union nor any officers, agents, or employees covered by this agreement will instigate, promote, sponsor, engage in, or condone any strike, sympathy strike, slowdown, concerted stoppage of work, concerted mass absenteeism, picketing, with respect to wages, hours, or terms and conditions of employment, or any other intentional interruption or disruption of the operations of the city, regardless of the reason for so doing. Any or all employees who violate any of the provisions of this article may be discharged or otherwise disciplined by the city in accordance with the applicable provisions of this agreement. In the event of a violation of this section, the union agrees to inform its members of their obligations under this agreement and to direct them to return to work. Section 10.2 No Lockout. The city will not lock out any employees during the term of this agreement as a result of a labor dispute with the union. Section 10.3 Penalty. The only matter which may be made the subject of a grievance concerning disciplinary action imposed for any alleged violation of Section 1 of this article is whether or not the employee actually engaged in such prohibited conduct. The failure to confer a penalty in any instance is not a waiver of such right in any other instance, nor is it a precedent. The city retains all rights set forth in Section 17(b) of the Illinois Public Labor Relations Act. Section 10.4 Judicial Restraint. Nothing contained herein shall preclude the city or the union from obtaining judicial restraint and damages in the event the other party violates this article. There shall be no obligation to exhaust the grievance procedure contained in this agreement before instituting court action seeking such judicial restraint or damages. Article 11, Wages. Section 11.1 Salary Schedule. Employees shall be paid pursuant to Appendix A of this agreement. Increases effective January 1, 2025 shall be fully retroactive. Step Movement. Firefighters/paramedics will start at Step 1. These employees will then move to Step 2 with 12 months of acceptable performance in the position, unless the employee falls into the exemption covered in Section 8.4. With acceptable performance, movement to Step 3 will occur on the following January 1st. Subsequent step increases are awarded each January 1st, subject to satisfactory performance. Fire lieutenants and fire captains move a step on each January 1st with satisfactory performance. The fire chief reserves the right to deny a step movement or to decrease an employee's wage rate by one step if performance is not satisfactory. If an employee contends the fire chief's decision to deny a step increase for unsatisfactory performance was unreasonable, such employee may file a grievance at Step 2 of the grievance procedure. Section 11.27 G. Compensation. In accordance with the Fair Labor Standards Act, FLSA, Section 7(g), the union and the city agree that when an employee works a voluntary, non-shift off-duty assignment, they shall be compensated at the following rates as described below. 7G training pay rate shall be at the employee's straight rate of pay as described in Section 11.3 and shall be utilized for training tower instructors/stokers, training division programs, VMO, TRA, CTVS, maintenance, etc., cadet instructor, fire prevention/inspections, and EMS training. It may be used for specialty team training, non-mandatory training, or required team training as decided upon by the team coordinator/leader. It may also be used for any other work that is mutually agreed to by the union and city. The employee shall be paid at their straight rate or 7G rate, whichever is greater. 7G project rate increase will take effect on January 1, 25 and be tied to the base wage rate increases as described in the chart below. The pay rate for the areas of public education, committees, non-mandatory meetings, station maintenance, radio maintenance, and other non-training instruction projects shall be. The parties shall mutually determine the level of 7G pay for work assignments on an as-needed basis. Section 11.3 Computation of regular hourly rate. The straight-time hourly rate of pay for shift employees covered by this agreement shall be calculated by dividing the employee's annual base salary by $25.95. The straight-time hourly rate of pay for employees assigned to a 40-hour week schedule shall be calculated by dividing the employee's annual base salary by 2080 hours. Section 11.4 Education pay. Upon completion of all requirements, receipt of associate's, bachelor's, or master's degree and submission of official transcripts of the degree to the deputy chief, all bargaining unit members will be eligible for and paid an annual stipend of $275 for an associate's degree, $475 for a bachelor's degree, or $675 for a master's degree. Employees will be paid a stipend for only the highest degree achieved. Such amounts shall be non-cumulative and shall be paid 1/26th at a time, as part of an eligible employee's biweekly paycheck. The stipend will begin in the subsequent pay period after the employee's verification of completion of degree to the deputy chief. Section 11.5 Experience pay. All bargaining unit employees with at least 10, but less than 15 years of completed service as a full-time sworn member of the Naperville Fire Department shall receive experience pay in the gross amount of $2,000. All bargaining unit employees with 15 or more years of completed service as a full-time sworn member of the Naperville Fire Department shall receive experience pay in the gross amount of $3,250. All bargaining unit employees with 20 or more years of completed service as a full-time sworn member of the Naperville Fire Department shall receive experience pay in the gross amount of $3,750. Such amounts shall be non-cumulative and shall be paid 1/26th at a time, as part of an eligible employee's biweekly paycheck. Section 11.6 Paramedic stipend. After successful completion of probation, all firefighters/paramedics with the Naperville Fire Department shall receive a paramedic stipend of 7% of current topped-out firefighter pay. Such amounts shall be paid 1/26th at a time, as part of an eligible employee's biweekly paycheck. The stipend will begin the first full pay period after the successful completion of their probation. All lieutenants and captains that retain their paramedic license will receive a stipend of 3.5% of current topped-out firefighter pay. This stipend shall be paid 1/26th at a time, as part of an eligible employee's biweekly paycheck. For newly promoted employees, the stipend will begin in the subsequent pay period after the employee's promotion date. Section 11.7 Personal time. In lieu of a paid personal leave benefit, the city shall make a contribution on behalf of each employee assigned to 40-hour staff positions in an amount equivalent to 16 hours of straight-time pay, less the amount of employee pension contributions due under the Illinois Pension Code, 40 ILCS 5/4-118.1, and pay it for the benefit of the employee to the trustee of the IAFF VIBA account, in January of each year. This city contribution shall be in accordance with Section 501(c)(9) of the Internal Revenue Code. Employees assigned to 24-hour shifts will receive 16 hours of personal time. The employee may use this time at their discretion as long as the following conditions are met. Notification for personal time use follows the same guidelines as Article 13 sick leave. No more than 4 members requested to use personal time during the same time frame. The time requested does not fall on New Year's Day, Easter, 4th of July, Thanksgiving, Christmas Eve, Christmas Day, New Year's Eve. The time requested is used in a 12-hour increment starting at 0700 or 1900. If an employee has any outstanding personal time hours remaining by the end of the year, they will be paid out at their current straight-time pay on the last payroll period of the year. Section 11.8 Shift versus staff differential. Bargaining unit personnel assigned to a staff position working a 40-hour workweek, rather than shift positions, will be paid a 6% wage differential. Section 11.9 Voluntary reclassification from firefighter/paramedic to firefighter. The City of Naperville Fire Department requires bargaining unit employees hired as firefighters/paramedics to maintain their EMTP license through the Illinois Department of Public Health throughout the duration of employment as a firefighter/paramedic with the City of Naperville, provided that a firefighter/paramedic may apply for reclassification from a firefighter/paramedic to firefighter, pursuant to a procedure established by the city, after they have been employed by the city as a firefighter/paramedic for at least 10 years. Such application will normally be approved, provided the city determines there will be no more than 8 firefighters per shift, and or no more than 24 firefighters in the bargaining unit. Except as otherwise provided herein, an individual who loses or voluntarily drops his EMTP license shall be subject to discipline up to and including termination. Any employee who is allowed to reclassify under this section shall be paid as a firefighter, not as a firefighter/paramedic. Bargaining unit employees promoted to fire lieutenant or fire captain have the option to drop their EMTP provided they maintain a minimum licensure as first responder defibrillation through the Illinois Department of Public Health. Any bargaining unit employee who was previously permitted to drop their EMTP license and subsequently restores their EMTP license with any EMS system at any time during their term of employment with the city must immediately inform the City of Naperville Fire Chief. Upon restoration of EMTP licensure, the employee must successfully test into the City of Naperville's current EMS system as an EMTP within 90 days of restoration and must function under the auspices and approval of said EMS system, regardless of any other standing he or she may possess with another EMS system. Section 11.10 Effect on pay based on promotion. An employee promoted to fire lieutenant will move to the first step, Step 1, in the lieutenant pay grade, regardless of whether the employee is at top pay in his/her pay grade prior to the promotion. Fire lieutenants promoted to the rank of fire captain shall move to the first step in the captain pay grade. Section 11.11 Pay periods and direct deposit. Regular scheduled pay periods are every 2 weeks with paychecks received on Friday. Direct deposit of paychecks shall be made available to employees. The regular amount for the 2-week pay period shall be based upon hours worked during the pay period. Mechanical or human failure may delay paychecks from being delivered normally, however, every effort shall be made to pay employees promptly. The city shall issue an equal and regular paycheck amount for each 2-week pay period. The city shall calculate each paycheck amount based upon the yearly salary applicable to the employee divided by 26 pay periods. Section 11.12 Holiday Stipend Pay, Shift Personnel. Each shift bargaining unit member shall receive a stipend for 12 holidays throughout the year. These holidays are New Year's Day, President's Day, Good Friday, Memorial Day, Independence Day, Labor Day, Veterans Day, Christmas Day, and 4 floating days of the employee's choice. Holiday stipends will be paid at 1.5 times their regular rate of pay for each of the 96 hours whether the holiday is worked or not. If an employee severs employment with the city for any reason and has been paid for holidays that have not occurred, the city will make the appropriate deductions on the employee's final payout to recover the unearned holiday hours. The city shall calculate each paycheck amount based upon the yearly salary applicable to the employee divided by 26 pay periods. This shall be paid out January 26th at a time as part of an employee's biweekly paycheck. Additionally, employees shall be entitled to receive a single 20-hour payment at the regular straight-time rate of pay in January of each calendar year, except that commencing in calendar year 2007 concurrent with the establishment of the IAFF-VIBA referred to in Article XX, Section 15 of this agreement, the city shall make a contribution from holiday pay due on behalf of each such bargaining unit employee in accordance with Section 501(c)(9) of the Internal Revenue Code. The employer's contribution shall be in the amount equivalent to 20 hours of the employee's regular straight-time rate of pay in January, less the amount of employee pension contributions due under the Illinois Pension Code, 40 ILCS 5/4-118.1. After deducting such pension contribution from the 20 hours of holiday pay due, this agreement authorizes the employer to deduct the remainder amount from the employee's holiday pay and pay it for the benefit of the employee to the trustee of the IAFF-VIBA account. Section 11.13 Holiday Pay 40-hour workweek employees. Sworn fire personnel assigned to a 40-hour staff position will receive holiday pay if required to work a holiday. Such pay will be in addition to the employee's base salary and shall be equal to 8 hours at the employee's hourly rate, as determined for purposes of this article by dividing the employee's annual salary by 2,080 hours, paid out at the rate of time and 1/2. If not required to work the holiday, the employee will be given the day off with pay. Generally, when a holiday falls on a Saturday, it will be observed on the preceding Friday. Generally, when a holiday falls on a Sunday, it will be observed on the following Monday. Employees assigned to a staff position will observe the following holidays: New Year's Day, Memorial Day, Independence Day, Labor Day, Veterans Day, Thanksgiving Day, Day after Thanksgiving, Christmas Eve, Christmas Day. In addition to the following holidays, the employee is given 3 8-hour floating days of the employee's choice. When particular calendar years present the need to deviate from the foregoing schedule of holidays, e.g., leap year, the final decision of when the holidays will be observed shall be at the discretion of the city manager. Section 11.14 Acting out of rank. An employee acting out of rank shall be compensated for all hours worked in the higher rank on such occasion, as provided herein. In such cases, the employee shall receive the pay rate associated with the first step in the next higher rank in which the employee is acting, except a captain acting as a shift commander shall be paid a differential of 4% above his regular straight-time hourly rate. Upon termination of the acting assignment, the pay rate shall return to the employee's permanent rank held with time and grade. Effective with the final posting of the next lieutenant's promotional list and thereafter, acting company officers shall be selected for each shift based on their ranking on the final promotional list according to shift. There shall be 10 acting officers per shift or at least 1 per piece of fire apparatus. In the event an officer and the acting company officer of a station are scheduled off, any employee on the current lieutenant eligibility register shall be considered qualified to act out rank regardless of shift or staff assignment. Selection for acting out of rank officers shall normally follow their ranking on the eligibility roster. Starting with the 2026 Lieutenant's Promotional Exam, the top 10 individuals from the eligibility roster shall be the primary actor on their assigned shift. Lieutenants acting in Battalion 2 shall be selected for each shift based off their ranking on the current captain final eligibility list. In order for the lieutenant acting in Battalion 2 to act out of rank, they must be already scheduled for duty and normally assigned to that shift. In the event the above criteria are not met, a captain must be hired back to fill the vacancy. Eligible lieutenants acting out of rank as Battalion 2 are not to be assigned to the role or duties of shift commander. Section 11.15 Charge Paramedic Stipend. All Community Advocate Response Team members are eligible to receive a stipend while working in the capacity of charge paramedic on IDPH designated transport units. Charge paramedic pay will be prorated hour for hour based upon an amount of $20 for a 24-hour period. Article 12, Medical, Dental, and Life Insurance. Section 12.1 Health Insurance. The City agrees to continue the benefits/plans currently provided for by the City at the same or substantially similar current levels for the duration of the agreement. Changes proposed by the City that affect the level of benefits received or the costs incurred by bargaining unit employees for any of the insurance benefits in this article shall be subject to negotiations between the parties. If the parties fail to reach an agreement, and the City implements any changes, the union may challenge that decision through the grievance arbitration provision of this agreement. Nothing in this agreement shall restrict the right of the employer to change insurance carriers or networks, self-insure and or change the method or manner of self-insurance, implement a health insurance program with multiple plan options that may include, but is not limited to, a high-deductible plan, health savings account, or health reimbursement account, participate in programs to reduce health insurance costs, or utilize health maintenance organizations or other similar groups. A summary of the benefits in effect upon execution of this agreement is attached as Appendix B1. A summary of the benefits that will take effect January 1, 2026 is attached as Appendix B. Section 12.2 Dental Benefits. Full-time employees will be provided a dental benefit program in which they may elect to participate. The City agrees to continue the dental benefit program currently provided for by the City at the same or substantially similar current levels for the duration of the agreement. Section 12.3 Terms and Conditions of Coverage. The extent of coverage under the insurance programs and policies referred to in this article shall be resolved in accordance with the terms and conditions in said policies, rules, and guidelines, including provisions governing self-insurance. While individual coverage claims shall not be grievable, nothing herein shall relieve the City of its obligation to maintain benefit levels as described in Section 1 of this article. Section 12.4 Employee Premium Contributions. Employees participating in the City health and or dental insurance programs shall pay a monthly premium contribution of 20% of the monthly premium applicable to the plan chosen, provided that for purposes of employee premium calculation, the monthly premium amount of each plan shall not exceed 115% of the previous year premium. The City shall adjust premium levels on January 1st of each year. The 2020 health and dental insurance employee premium contributions are set forth in Appendix C. The City shall have the right to implement new employee premium contribution rates on January 1st of each year consistent with the above language, regardless of whether the collective bargaining agreement has expired. Nothing herein shall restrict the union's right to bargain over the terms of medical and dental insurance. Section 12.5 Medical Expense Reimbursement/Dependent Care Assistance Plans. The City shall offer a medical expense reimbursement plan and or dependent care assistance plan in which bargaining unit employees may participate. Section 12.6 Life Insurance. Full-time employees are eligible for employer-paid life insurance in the coverage amount of 150% of their base pay but not less than $20,000. Full-time employees are also eligible for employer-paid accidental death and dismemberment benefits. Death benefits shall be paid to the employee's designated beneficiary. A supplemental voluntary life insurance plan is also available for purchase by full-time employees. The City will pay for the funeral expenses of any bargaining unit employee who dies from injuries or illness received while acting in the line of duty. Section 12.7 Reopener Agreement. The Union and City agree that on November 30, 2025 and November 30, 2026, the Union shall have the right to reopen the agreement for the specific purpose of proposing that the City agree to allow all bargaining unit employees, collectively, to move from the City-sponsored medical and dental insurance plans to plans proposed by the Union. The effective dates of the new plans would be January 1, 2026 and January 1, 2027 respectively. The City agrees that it will bargain in good faith over this issue and over the terms proposed for any such move. The Union agrees to waive any right it may have to interest arbitration over this issue as provided for under the Illinois Labor Relations Act. This reopener and the waiver shall expire on December 31, 2027.